Hey everybody, how's it going? Welcome back to Copper Jacket TV. So the Ninth Circuit Court of Appeals strikes again, proving once more that they care more about their agenda and activism than they do about upholding our nation's Second Amendment rights. While the rest of the country is appreciating new leadership and new management for agencies that might actually lead to change, like Harmeet Dillon in her latest tweet, where she says Second Amendment rights are civil rights. For far too long, states and localities have been abridging those rights openly. Others do it through encroaching regulations, delays, etc. Protecting these fundamental rights is critical to the Justice Department and at Pam Bondi. So while the rest of the country gets to be a little bit excited about what the future might hold for the Second Amendment, states that are under the control of the Ninth Circuit Court of Appeals and several others have to deal with stuff like we're talking about today. A new decision was just filed by the Ninth Circuit Court of Appeals, once again going against the Second Amendment. Let's talk about it. Now, real quick before we get started, if you're watching this video and you've not yet subscribed, consider hitting that subscribe button. It helps us out more than you could possibly imagine. Not only does it help us spread our message, but it also lets the powers that be know that people want to see content like this, which allows us to stay on this platform for a little bit longer. So thank you to everybody who subscribes. I really do appreciate it. Okay, so let's go and talk about what's going on here. Now, some of you might remember that just last year, we were all shocked by a decision from a 3-judge panel of the Ninth Circuit Court of Appeals when they determined that nonviolent felons should not lose their Second Amendment rights. That's not something that you typically hear from the lower courts, especially from the Ninth Circuit, who has proven time and time again that they absolutely loathe the Second Amendment. But that's what happened. Now, it wasn't as much of a surprise when we found out that Judge Van Dyke was one of the judges on that 3-judge panel. He's the same judge that gave the video dissent in Duncan v. Bonta, proving that the Ninth Circuit was allowing California to infringe on your Second Amendment rights. Now, this is really important to pay attention to, but in that opinion that was written last year by Judge B, the judge writes 18 U.S.C. 922 G1 makes it a crime for any person to possess a firearm if he has been convicted of an offense punishable by imprisonment for a term exceeding 1 year. I don't know about you, but that seems like a pretty low standard for losing your Second Amendment rights to me. Stephen Duarte, who has 5 prior non-violent state criminal convictions, all punishable for more than a year, was charged and convicted under 922 G1 after police saw him toss a handgun out the window of a moving car. Duarte now challenges the constitutionality of his conviction. He argues that under the Supreme Court's recent decision in NYS RPA v. Bruin, 922 G1 violates the Second Amendment as applied to him, a nonviolent offender who has served his time in prison and is re-entered society. We agree. Now, that decision can't be allowed to stand, right? I mean, the Ninth Circuit has their agenda to consider. So that ends up going en banc, where a vast majority of the judges from the Ninth Circuit decide to rehear this case. Now, what is different this time is that when it goes en banc, they decide to hear it de novo, which basically means that they're going to rehear United States v. Duarte as if it is brand new, not considering anything that was written in this incredible opinion by the 3-judge panel. They're just going to hear it on the merits as if it was a brand new case. And what does the Ninth Circuit decide to do? Well, they decide that they're going to rule in exactly the opposite direction of that 3-judge panel and say that it is perfectly constitutional to remove the rights of a large swath of the population just because they were imprisoned for more than 1 year. That's pretty much it. So they upheld the non-violent felons ban for Second Amendment rights. Now, even though Judge Van Dyke was on the original panel that said that nonviolent felons should not lose their Second Amendment rights, he was also on the en banc panel. So we have an incredible dissent from Judge Van Dyke in this one, and I hope this one goes up to the Supreme Court. But the FPC, the Firearms Policy Coalition, who actually joined alongside the NRA in this case, pointed out some amazing quotes from Judge Van Dyke, kind of proving the point here. Now, in one of the quotes that the FPC highlights here, Van Dyke says, "Try to imagine any other constitutional right that the members of this majority would treat the way it treats the Second Amendment. And that is absolutely true. If you're talking about First Amendment, Fifth Amendment, 14th Amendment rights, the court sees things completely different. But anytime it comes to the Second Amendment, that's what you get. Now, the FEC also highlights another quote where Van Dyke says, "Once again, we demonstrate our court's deep-seated prejudice against a fundamental constitutional right, and I must respectfully dissent." And isn't that true? And Judge Van Dyke, the Honorable Judge Van Dyke, if you ever want a platform to tell people what you're really thinking, you're always welcome on here. Now, the real key takeaway here is that any state that's within the Ninth Circuit's jurisdiction could see this as a way to impose further bans on the Second Amendment. All they have to do is change how certain laws are punished, and it could get them to fall under 922G1. If they can get a law that was previously not punishable under 922G1 to then be punishable under 922G1, you could end up seeing a lot more people lose their Second Amendment rights, which is absolutely unconstitutional. You just can't do that. So hopefully, again, this goes up to the Supreme Court, and maybe the Supreme Court actually considers this one. Because, again, this is another case that is just completely done. It's ready for the Supreme Court, but whether or not it will go up there, I still don't know as of yet. But I wanted to update you on that. It looks like the Ninth Circuit is doing a little bit of a flip-flop like they typically do when we get a good decision from a three-judge panel. The Ninth Circuit's en banc panel will always make sure that any pro-2A decision gets reversed, and that's what they did here. So I wanted to let you know about that. I want to thank you all very much for watching. I really do appreciate it. If you haven't done so already, hit that subscribe button. That little like button is always appreciated. That little alarm bell will let you know when new videos come out. With that being said, you all have a great day.